The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. You may be seated. All right, good morning. We are ready for our first case, and that is United States of America Sheldon United States of America versus Perez. And we will start, Ms. Hashimoto.
Yes, Your Honor. Erica Hashimoto. I am at the Georgetown Law Center's Appellate Litigation Clinic. And with the court's permission, Ryan Mentor, a third-year student at the Appellate Litigation Clinic at Georgetown, will be presenting argument on behalf of both Mr. Perez and Ms. Coleman.
Thank you.
Thank you.
All right. Yes, sir. Mr. Mentor.
Good morning, Your Honors, and may it please the court. The district court's judgment should be reversed because it failed to apply both Knights and Hill, the controlling case law. Mr. Perez's supervised release conditions allow for warrantless searches and seizures of his person and property. But person and property does not include residence for two reasons. The first is that the Fourth Amendment gives the most stringent protections to home. And the second, when read in harmony with Mr. Perez's additional supervised release condition, that his home could be visited by probation officers and contraband in plain view could be confiscated. Person and property must mean something other than residence. Even if person and property did include residence, the Fourth Amendment would still bar the evidence from coming in, both because Ms. Coleman was not on notice that her home could be searched, and the requisite standard for believing that Mr. Perez lived at Teal Drive, probable cause, was unsatisfied. And finally, there were numerous disputes as to material fact below, such that granting summary judgment was improper. Turning first to the interpretation of person and property. The inquiry is whether Mr. Perez's expectation of privacy was significantly and unambiguously diminished. That standard comes from Knights, and in Knights, the supervised release condition included person, property, residence, and vehicle. This court's interpretation of Knights and Hill found that the inclusion of residence was critical to Knights' determination. The exclusion of residence should be critical here too, both because homes are given the most stringent protection under the Fourth Amendment. After all, the chief evil against which the Fourth Amendment was enacted was unreasonable searches of the home. But second, Mr. Perez's supervised release condition included home elsewhere. It allowed for visits and confiscation of contraband found in plain view. If person and property included home, then this additional condition would have been unnecessary because plain view searches, as well as full search and seizures, would have been covered by the former.
Mr. Mentor, if property doesn't include, homes, then what does property include?
Well, here property, Your Honor, would include movable items that were outside of the home. The fact that home is included elsewhere tells us that home wasn't meant to come in within the ambit of person and property, at least for warrantless searches and seizures. For plain view searches, yes, but not for the full search and seizure that we have here.
So what you're saying then, Mr. Mentor, is that the term property means tangible property?
In this instance, yes, Your Honor, where home is listed elsewhere, property would mean movable items outside of the home.
Okay, aren't you adding words, though, to the term?
I'm sorry, Your Honor?
We have to add the word tangible to accept your argument, don't we?
Not necessarily, Your Honor. This court could hold that property means movable items outside of the home without adding any terms because home is listed elsewhere. Whether it includes beyond tangible items, what it unambiguously excludes is home, because home is somewhere else in the search conditions, in the supervised release conditions, rather. And finally, Officer Mosqueda included an inaccuracy in his sworn affidavit. He told the district court in the affidavit that Mr. Perez, quote, as a condition of his supervised release, was required to submit his person, residence, and vehicles to warrantless searches. He further stated that the conditions of release required Perez to, quote, notify other occupants of his residence that the residence could be subject to warrantless searches. But both of those assertions are wrong. If Mr. Perez's supervised release conditions contained such language, that would have put him on notice that his home could have been searched. But neither of those statements were included in the conditions. And the district court relied on those assertions, and that in and of itself is enough for reversal.
If we were to agree with you that probable cause is the standard and there was no probable cause here, or at least there's a dispute of fact as to probable cause, do we even need to reach the question about the question of the meaning of property?
Yes, Your Honor, because the belief that property was included was the justification for searching the properties. So the belief that home was included within person and property was the basis upon which the home was then searched, thinking that the supervised release condition included home when it did not.
But the Teal Drive property wasn't his home, right?
Right, Your Honor, it was Ms. Coleman's home.
Or at least that's the question whether they had probable cause to believe that.
That he resided there, yes, Your Honor.
So if we were to find that there was a question of fact as to whether they had probable cause, then we could leave for another day the question of the meaning of the word property.
Yes, Your Honor, if there was no probable cause to believe that he lived at Teal Drive, then all of the evidence could be kept out under that theory as well. The misstatements that Officer Mosqueda made in regards to property wasn't the only misstatement of the record that was relied upon below, Your Honors. Besides Officer Mosqueda, Officer Mani also claimed in affidavits that Mr. Perez was obliged to inform people with whom he shared a home that it could be searched. The district court relied on that too, and the government now acknowledges at page 38 of their brief that that assertion was false. In actuality, Ms. Coleman was not on notice that her home could be searched. Ms. Coleman needed at least the same standard as those on supervised release, because her expectation of privacy is entirely unimpaired. And that standard is that for her to have been unambiguously and significantly, her expectation to have been so diminished that her home could be searched. The government could have required Mr. Perez to inform her that this condition is commonplace in many of the supervised release conditions that are issued today, but they didn't include that provision. As we were just discussing, there also was no probable cause to believe that Mr. Perez lived at Teal Drive in the first instance. Only 2 circuits have considered whether the proper standard for believing that a supervisee lives at an unregistered dwelling should be reasonable suspicion or probable cause. And both of them, the 8th and the 9th, have held that it should be probable cause for 2 reasons. The first is that it could possibly implicate, and here it did implicate, the unimpaired privacy rights of non-supervisees. But second, it poses no substantial burden to probation officers that have enough evidence in the first instance to believe that the non-supervisee lives somewhere other than the registered dwelling. There are a number of factors that courts consider in reaching this probable cause determination, such as whether the unregistered dwelling was used as the home base, officers directly saw the supervisee living, coming and going from that place, and whether they had a key. But none of these factors are present here. There's no evidence that Mr. Perez had a key to Teal Drive. The officers, there's no evidence that they saw him coming and leaving from that residence.
Now, let me ask you this, but there is evidence that he owned Teal Drive, or previously, I guess, resided there. Is that correct?
Yes, Your Honor. He previously lived at Teal Drive, and there's evidence that he owned that, but that evidence was not known until after the lease was put into the record. There's a question as to when that was known, that he owned that address. But it certainly doesn't counsel towards a finding that he lived there, especially when we consider that in 2020, Mr. Perez was visited on 12 occasions by Officer Mani, and every single one of those times he was at Lawndale. He was present and at that address for every single visit. The only evidence that the government could rely upon for the probable cause determination could be the informant, the confidential informant. But this confidential tip is not enough. This court held in Kehoe that anonymous tips are rarely enough because they don't provide a strong enough basis to consider the basis of knowledge and the veracity of the informant and how they know what they're reporting. We have the same problem here. We have no guarantees of reliability or corroboration. Various cases have found reliability and corroboration where the police were able to interview other bargoers, observe the speech patterns of the individual in question. They went and met with the informant, or the informant had given information in the past that led to successful convictions. We have none of those guarantees of trustworthiness here. All we have is an anonymous tip. We don't even know the name of the person, and so there's no reliability or corroboration to be had. And the same problem comes up even if this court were to conclude that reasonable suspicion was the standard instead of probable cause. Corroboration and reliability is required similarly for reasonable suspicion, and we don't have that here either. And finally, Your Honors, there are a number of genuine disputes as to material facts, such that granting summary judgment below was improper. The first was the district court's determination that there is no verifiable source for the income. Mr. Perez worked at Custom Hot Whip South, making $1,300 per week. Ms. Coleman at one point had 2 jobs, making between $75,000 and $80,000 per year. And there are bank statements here accounting for nearly all of the funds that were seized. The government faults Mr. Perez for not providing pay stubs to account for some of his Custom Hot Whip's salary. Mr. Perez has said in multiple affidavits that within the blue nylon bag that was seized, there are pay stubs in a zippered compartment, and those have not been returned. And requiring them to provide pay stubs in the first instance shifts the burden. CAFRA places the burden on the government at all times at a preponderance of the evidence. It's not on Mr. Perez and Ms. Coleman to prove that the money here was tainted. That burden falls on the government, and it remains with them. Another question of material fact was the conclusion that such sums of money near drugs always leads to the inescapable conclusion that drug trafficking was afoot. McClellan expressly rejected such a conclusion, finding that where there are multiple plausibilities, as there are here, one that there was drug trafficking afoot and the other that there are innocent explanations for the items that were seized, then summary judgment is improper. And in those cases where trafficking was found, there were vastly different amounts of money, huge sums, hundreds of thousands of dollars. One case had 18 pounds of marijuana, another had 2,500 grams of controlled substances. Here we're talking about 2 grams of heroin, 1.7 grams of fentanyl tramadol mixture, and $25,000, nearly all of which is accounted for with bank records. Another dispute was what the presence of heroin means. Mr. Perez says it's for pain management and personal use, and the government says that the very small quantity that was found is indicia of trafficking. And the last genuine dispute was the presence of cocaine in the home. The government asserted that the 8 ounces of white powder that was seized from the kitchen was cocaine. Then they changed their mind and claimed it was fentanyl. The lab reports have come back and indicated that it tested negative for all controlled substances. In short, the government's case is anything but airtight, which is what this court said it needed to be in McClellan for summary judgment, and the grant of summary judgment here was improper. If the court has no further questions, we would respectfully ask that the judgment below be reversed and the case remanded with instructions to dismiss the verified complaint. Thank you.
All right, thank you. All right, next, we will hear from Mr. Stroop on behalf of the government. Thank you.
Good morning. May it please the court. Nathan Stroop for the appellee, United States of America. If it pleases the court, I would like to start by discussing the reasonable suspicion and probable cause issue in this case, because I believe it lies at the heart of this appeal. And I want to make clear that this is a case of first impression for not only this circuit, but for all circuits. Although Mr. Perez and Ms. Coleman have cited cases out of the 8th Circuit and 9th Circuit for the proposition that probable cause is the standard to be applied to determine whether there is sufficient suspicion that a defendant is residing at a secret residence. This case is significantly different because it involves a probationary search by the U.S. Probation Office. In the cases in the 9th Circuit and the 8th Circuit, those were state parolees, and the searches were conducted by ordinary law enforcement officers. As this court knows, U.S. probation officers have a very significant but limited interest to serve in the criminal justice system.
What about the interests of the other resident of the property, Ms. Coleman? Doesn't that factor into the analysis at all?
It does. It does indeed. And considering in Knights, the Supreme Court noted that this court must balance the interests of third parties, the Fourth Amendment interests, against the governmental interests and strike a balance. That balance is struck here, even considering Ms. Coleman's Fourth Amendment rights by the application of reasonable suspicion.
But it's pretty sketchy information that they had, isn't it? I mean, we know the probation officer, quote, conducted surveillance, but we don't know what that entailed, do we?
I look at the facts and circumstances in two categories, Judge Keenan. In one category, we have sort of historical facts and circumstances that had some age on them, granted, by the time the search of both Lawndale Drive and Teal Drive was conducted on January 4th, 2021. Those are the tip of the confidential reliable source, which, by the way, is not an anonymous tip. It's a confidential reliable source tip. We had surveillance by the U.S. Probation Office of Mr. Perez with no further detail in the record. I would like to highlight, yes, I would like there to be in the record additional detail as to what that surveillance entailed, but we are limited to the record. And probation office knew that Mr. Perez had lived at Teal Drive from September 2016 to April 2019, and they also knew that he had a history of violating the conditions of his supervised release. Now, those are the sort of, I'll call them the historical facts. Then we have the day of evidence. On the day of the search of Teal Drive, before that search began, U.S. probation learned a lot of material facts here that pertain to both reasonable suspicion and, if this court applies, probable cause. They searched the Lawndale Drive location that he had reported living. They found prescription pill bottles with his name, Mr. Perez's name on it, and the address of Teal Drive.
Let me ask you about that, because
Yes, Your Honor.
my understanding of the events of the day is that they were searching the Teal Drive and Lawndale simultaneously. So they were already at Lawndale, right?
That is incorrect, Your Honor. If you review the record at JA 19 to 20, that is the declaration of the TFO officer that was attached to the government's complaint and submitted in support of summary judgment here. It is clear from that account that the Lawndale Drive search was conducted first, and then they moved to the Teal Drive location. It is also consistent with Mr. Perez's declaration in this case at JA 94, which he entails the search at Lawndale Drive, and then next the search at Teal Drive.
But they were already, my understanding is they were already headed to Teal Drive, or at Teal Drive. There's some overlap in the time of being at Lawndale and Teal.
I think what was contemporaneous was that, and granted, U.S. probation had determined to search both properties before they left the office, okay? But what actually happened, and it's supported by the record, is that the Lawndale Drive property was searched first, and then they went to the Teal Drive location. And so all facts and circumstances that they learned, which are significant from the Lawndale Drive search, apply to the whatever legal standard, reasonable suspicion, or probable cause that this court applies to the Teal Drive.
What you say that they were significant facts and circumstances, what else other than the prescription bottles with the Teal Drive address did they find that led them to have either reasonable suspicion or probable cause that the Teal Drive address was in fact the address of the residence? Was there
Yeah.
anything else?
Yes,
I mean, I
Judge.
think a number of us don't change necessarily our address with our pharmacy after we move. We keep picking up pills at CVS, and it's got our old address, and it takes a while to update your address.
Granted, not everyone updates their address with the pharmacy, but in terms of the totality of circumstances, I think that that's a material fact. In addition, to answer your question, Judge Berner, at the Lawndale search, Mr. Perez drove up in his van, and a canine dog was deployed, and it alerted to the presence of the odor of narcotics on the van. The van was searched. A trap compartment was found within the van that is consistent with storing or transporting narcotics.
And what's the connection between that and Teal Drive?
That's more tied to drug activity, but if there is a tied to Teal Drive, and I think that there is. Probation had received a tip, information from a confidential, reliable source that Mr. Perez was living at Teal Drive and back involved in drug activity. When they find evidence suggesting that, yes, he is involved in drug activity, that is beginning to corroborate the information received from the
Let me
confidential.
ask you this, though.
Yes, ma'am.
So they go to Lawndale. He is there. The job of probation is monitoring the probationer. Is that correct?
That is correct, but what's not correct is that he was at Lawndale when they arrived.
Well, he shows up there.
He does
And
show
based
up.
on what you just said, they didn't search Till until after he showed up and found the pill bottle in I think, in the car. So if the purpose of probation and their job is to monitor the probationer, they find drugs and other contraband at Lawndale, why would at that point they have a warrantless search of Teal Drive? It seems to me as at that point, and law enforcement was there, that would have been the point where you say, hey, let's get a warrant from a magistrate and then search Teal Drive.
One of the suspected violations was drug activity. Another suspected violation was failing to report the residence. In
I
other words-
understand, but the violation as to the probationer, him being on probation. So it seems as if Lawndale, for probation's purposes, they met, they came, they found what they were looking for. He's in violation of his probation. They have the evidence to present that he's in violation based on
Yes, sir.
his presence at Lawndale and the contraband that they found at Lawndale.
Maybe I can clear that up, because I don't think that they found contraband at Lawndale. I think that they found facts and circumstances giving rise to probable cause or reasonable suspicion that they're going to find contraband at Teal Drive, which is exactly what the confidential, reliable source advised them. He's living there. He's back conducting drug activity there. And another fact and circumstances at
Isn't it true that the canine search that you describe occurred after the decision to go to Lawndale and search Lawndale? Excuse me, to go to Teal Drive and search Teal Drive?
Yeah, I think it's clear on the record that the decision to search both residences was made before the first search of Lawndale. However,
And before the canines?
and before the canines.
And
However,
so how could it be, my first question I asked is what facts were sufficient to form either reasonable suspicion or probable cause? And what I've heard from you is the pillboxes and the anonymous informant. Is there anything else?
yes, there is. He also denied knowledge of Teal Drive when law enforcement said, okay, we're going to be heading over to Teal Drive. He says, I don't know anything about Teal Drive. Reasonable inference is that that's incorrect. We know that. He used to live there. Probation knew that. Why is he lying to the probation officers? Reasonable inference is he doesn't want to be connected to Teal Drive. Why? Because that's where he actually lives, and that's where they're going to find evidence of drug activity, which is exactly what happened.
Well, get back to the confidential informant for a minute. What is there in the record that shows the reliability of this confidential informant?
We have the probation officer's declaration saying that after he received this information, he conducted an investigation, including surveilling.
Right, but we don't know
Perez.
what that investigation was. It seems to me it's kind of a house of cards. If you don't have anything in the record to establish the reliability of the confidential informant, then the confidential informant's information isn't worth a lot. It could just be anybody.
Right.
And then you're attempting to build on that foundation the probation officer's statement that the probation officer conducted surveillance, but we don't know what the surveillance was. So it seems to me you're asking us to kind of pile inference upon inference rather than providing a solid factual basis for why you think there was grounds to go into that house on Teal Drive.
I think historically, the historical facts I refer to, we need more. Fortunately, we have day of evidence from Lawndale that further corroborates the information from the confidential, reliable source that Mr. Perez was living back at Teal Drive. They find pill bottles. He denies any knowledge of Teal Drive and the drug activity as well, by the dog alert and the trap compartment. That information, I think, reasonably, again, the touchstone of the Fourth Amendment is reasonableness. I think that reasonably corroborates the information from the confidential, reliable source and gets them into the door at Teal Drive.
Let me ask you this, it's
Yes,
Mr. Mentor brought up this point regarding Mr. Perez is on probation and I guess his consent to the terms of his probation, and how does that diminish the Fourth Amendment rights of Ms. Coleman?
I don't think
Who's
Mr.
at the house,
Yes,
who
ma'am.
says, she says, this is my apartment, she and her daughter are there, and I don't consent to the search, and they pretty much said, go outside and we're gonna search anyway.
Right. I don't think that to answer your direct question, Judge Benjamin, Mr. Perez's consent does not diminish a third party's Fourth Amendment rights. That is not the position of the United States. The position of the United States is we need to determine what's reasonable under the facts and circumstances and strike a balance. And given the special government interests that probation serves, that this court has recognized as recent as yesterday in an unpublished opinion released yesterday in U.S. v. Rocco, U.S. probation serves important government interests in protecting the community from future crimes, combating recidivism, and promoting the rehabilitation and reintegration of the defendant. They're there to help him. These are very limited but very significant interests that must be balanced against Ms. Coleman's Fourth Amendment rights. And I think on the balance, you strike the balance at reasonable suspicion. I think the record supports reasonable suspicion. Alternatively, if this court were to hold probable cause, I think we could rely on the record here that supports probable cause.
Do you think it matters that Mr. Perez was not at the Teal Drive? Does it matter that he was not there, considering he's the probationer that probation is monitoring, that he was not at the Teal Drive address?
Under the facts and circumstances, of course, all facts and circumstances matter that are material to that. I would never say no. But we have to look at the facts and circumstances and apply common sense. He drove up while the search was going on to Lawndale, from where the record is silent. He was placed in custody, and I believe it's in the record that he was taken back to Teal Drive. I'm not 100% sure on that. But of course, he would not be at Teal Drive when that search was conducted because he had arrived at Lawndale Drive and was taken into custody at that time.
So in your brief, you say that Coleman's expectation of privacy was diminished. Are you no longer standing by that position?
I'm not pursuing that argument today. I think we have stronger arguments in terms of the government interest served by the probation office in striking a balance against third parties' interests. And that's an issue no Court of Appeals has taken up in the context of U.S. probation. The Supreme Court, in its trilogy of cases discussed by all the parties in this case, Griffin, Knights, and Sampson, have repeatedly recognized the special, important, substantial, and overwhelming, their words, interests served by the probation office in the criminal justice system. If probable cause were to be the standard applying to U.S. probation officers, that would de facto cause them to seek a warrant in this situation. And that would replace their judgment with the judgment of a magistrate judge, which...
Well, what's wrong with that when you have a situation? I mean, we've already said in Brinkley, Judge Motz's opinion about 5 years ago said that the police need probable cause to enter a residence, didn't they?
They did. Ordinary law enforcement, yes, not U.S. probation. And the Supreme Court on multiple occasions had said, we should not be slowing down probation officers. We should not be requiring them to go get a warrant. These people they serve a special interest. They need to act quickly to serve the interests that I've outlined.
But you have to have the facts behind you. See, that's what's bothering me about your case, is that they were always visiting, the probation office was visiting him, Mr. Perez, at Lawndale Drive, weren't they? I mean, that's
They
where
were, and I'd like to clear up in the record because it's
Yeah,
at least
how-
implied in
how many times had they visited him at Longdale Drive?
they were monthly visits in 2020.
Uh-huh.
I want to make clear, because I believe Mr. Perez.
It was 12, right?
I'm sorry,
12 visits, right?
12 visits, 12 monthly visits.
Okay, so there was a strong historical record that he could be found at Lawndale Drive.
Not, I would say no. And
Why
that's-
is
That's
that?
the point I wanted to get to, is in their reply brief, they at least imply that Mr. Perez was home. He answered the door. Hello, how are you doing? That is not in the record. There's nothing in the record, and I'm not going to go off the record, but there's nothing in the record to support any allegation that Mr. Perez was home during those 12 visits.
But it's interesting that he shows up at Lawndale Drive. when they arrive, and he shows up at Lawndale Drive. I think that the problem I have is the job of probation is to monitor and supervise the probationer. He's not at Teal Drive. And so I guess that's where I'm hung up, is that he's not at Teal Drive. He shows up at Lawndale, and at Lawndale, he's there, probation is there, and then that's when that search occurs. It just seems as if it would have been more, it seems like it would have been proper to then at that point get a search warrant to search Teal Drive if you said you had probable cause.
And I think that that's what ultimately happened shortly after the Teal Drive.
But not until they go in the house and start going through the kitchen. It wasn't even
Correct.
plain view. I mean,
Correct.
if you want to get into the whole property, is it property and what can be searched? They go in and they start searching because they find the cocaine in the lemonade.
Suspected white powder.
Okay.
That yes, was later tested and was not shown to be a controlled substance.
Okay, so they go, but they're clearly in the kitchen looking through things in the kitchen with no warrant, and then they go back and get a warrant to search the entire house.
Correct. That's when the sheriff's deputies who were there to assist do that. That is correct, Your Honor. In the 1 minute I had, unless the court has more
Well,
questions.
and I think, and I don't mean to cut you off there, but Mr. Troop, I've got a question too.
Yes, Judge.
Let's say we disagree with you. We find that probable cause was required and that probable cause is not shown on this record. What do we do with the case?
I'm glad you asked that question.
Because why would the government get a second chance to prove its case when it didn't put on the evidence in the first place to meet the probable cause standard, if that's what we find? So what do we do with the case? Do we send it back or not? Send it back to determine who gets what money? Or are you saying that the entire case is still in play, that the government gets a second bite at the apple and gets to try to prove its case under the probable cause standard? Where are we left if we disagree with you on the issue of probable cause?
Under that scenario, I think this court would remand the case to the district court to apply the correct standard, because the district court applied reasonable suspicion. If this court determines that the correct standard is probable cause, then we need to give the district court the opportunity and the parties the opportunity to take up that standard and hold a hearing. Just to have a couple more seconds, I wanted to add, because there's a traditional motion for summary judgment argument here that largely depends on the McClellan case. The differences between McClellan in this case are night and day based on the evidence. The evidence in McClellan was extremely thin, as this court noted, and here we have a proverbial mountain of evidence that includes serious drugs, 195 oxycodone pills, money counters, digital scales, a money bag, handguns, ammunition, all found within, in and around hidden bulk U.S. currency. We also have the claimants, Mr. Perez and Ms. Coleman, have both either pled guilty or been found guilty of drug crimes tied to the drugs found at Teal Drive that day, including Mr. Perez being found guilty of possession of heroin with the intent to distribute it. I think this is a strong collection of evidence that, if we get to that stage, will support the summary judgment for the government, and I ask that the court affirm the district court's judgment. If the court has no more questions, this submits our argument.
Thank you. Yes, sir, Mr. Mentor.
Thank you, Your Honors. The government relies on various items from Lawndale to claim that the probable cause standard was satisfied, and I'd like to go through a couple of those. The first is the prescription bottle. No case has ever held that forgetting to change your name with a pharmacy is indicative of probable cause that you live at an address. Many of us forget that our address is registered at a different place, and we continue to just pick up medications and we don't change it. Probable cause has never been found in that instance. There's also a question about whether the canine alerted on the van at all. There was also nothing found in the trap compartment. But perhaps the most important point about both the bottle and the van is that the government concedes at pages 323 and 324 of the joint appendix that evidence was found, and the search of, and the alert on the van, or the alleged alert on the van, was after they already made the determination that they were going to search to search Teal. That information added nothing to the analysis at all. The government relies on the conclusory assertion that there was surveillance and follow-up investigative tips without anything more. This tip came in December of 2019, and the search was in January of 2021. The government had 14 months to provide anything, something more than these conclusory allegations, for the court to find both reliability and corroboration. They have failed to do so. Next, the government has conceded that Mr. Perez's consent would not have diminished Ms. Coleman's privacy expectations, so a warrant would have been required to search the home. The government argues that for probable cause, the proper remedy, if this court determines that as the standard, would be a remand, but that would give the government a second crack at putting evidence in. They've already put evidence in. It wasn't enough to establish probable cause, and they shouldn't be granted a second bite at the apple, if you will, to try again. But the primary evidence that was relied upon anyway has tested negative for controlled substances. And finally, on the summary judgment point, the government argues that this case is much weaker than McClellan. There are actually a lot of elements to this case that are stronger than McClellan. There's no cocaine found on the money. The funds weren't being driven around with in a car. There were small quantities of drugs and money. And there are logical explanations for each of the items that were found here. To just go through a few, the scales Mr. Perez has said were used for weighing personal quantities of marijuana. The cell phones were for his car business, for employees. They were disconnected. And there are explanations for each and every one of those items. Lastly, the government makes much of the Alford plea that was entered by Mr. Perez. Mr. Perez did not plead guilty. He entered a plea in accordance with Alford v. North Carolina, admitting that the government had enough evidence to prove their case, but not a guilty plea. And even with those pleas intact, the burden is still on the government to prove that this money, all of this seized money, is connected to drug trafficking. They cannot do so here.
I have a question about the 14-month period between the confidential informant and the search. Were the 12 visits to Lawndale in that time period? In other words, did the probation officer continue to go to Lawndale after the confidential tip?
Yes, they did, Your Honor. At no point did they go to Teal. The confidential tip was received in December of 2019. They visited Lawndale once per month from January through the end of December 2020. Never once going to Teal. Mr. Perez was at Lawndale every time. And in January of 2021 was when they searched both residences. If the court has no further questions, we would respectfully ask that the judgment be reversed and the case remanded with instructions to dismiss the verified complaint. Thank you.
Thank you. Thank you, and I wanted to acknowledge the Georgetown Law School and thank Professor Hashimoto. Yes. And also Mr. Mentor for being here and recognize that they are court-appointed, and thank you for being here and for your service. At this time, we'll step down and greet counsel, and we will get ready for our next case. Thank you. Our second case is 24-1959, David Gasper versus EIDP Inc. et al. And representing Mr. Gasper is Mr. Tyson.
Yes, Your Honor. Good morning.
Good morning. We'll give you a second to get set up, and then we'll be ready to start. Yes, sir.
Good morning, Your Honors. May it please the court, my name is Brian Tyson with the law firm of Marcelino and Tyson, and I am here today representing the appellant, David Gasper, who's here in the courtroom with us. I wanted to start out and just briefly tell you what I think the case is all about and then give you a little roadmap for what I wanted to talk about today. The overarching question in this case is whether a plan administrator of an ERISA plan may rewrite a state court judge's order that was lawfully written, lawfully entered, and represents the bargain for contract between two parties to a divorce. Now, there's three parts to this I wanted to talk to you about. And Your Honors had asked us to talk about Fox versus Fox, so that's the first thing I wanted to talk about with respect to the standard of review for a plan administrator's review of a DRO, or a domestic relations order. Second, I wanted to talk about the methodology that the district court used to interpret under North Carolina law to interpret a contract, and that the district court erred in that regard. And then third, I wanted to talk about the legal error that the district court committed by excluding David's declaration with respect to the statutory penalties claim under ERISA, wrongfully believing that an administrative process was required under ERISA with respect to that statutory claim. So the first issue I wanted to talk about that Your Honors had asked us to address is the Fox versus Fox case, and specifically the correct standard of review for a plan administrator's review of a DRO, the domestic relations order. The district court did correctly hold that that standard of review is a de novo standard. The Fox case actually does not address that question. In Fox, what happened was the participant had gotten a DRO, an order from the Maryland Family Court. She took that to the plan administrator, who actually happened to be her ex-husband, and presented that DRO to the plan administrator. The plan administrator said, yes, this is a qualified domestic relations order, I will pay you. The Maryland Family Court then went back and said, wait a minute, we miscalculated. We got the wrong amount, you're actually due more money, participant. So the participant then took the subsequent family court order, goes back to the plan administrator the second time and says, oh, they made a mistake, I need more money and you're supposed to pay me out from this. The plan administrator said, no, I'm not gonna do that. The reason being is that I think that it's only, that the words lump sum within the plan. In other words, the plan administrator was interpreting the plan in that case. I think lump sum only means one payment. You're asking me to make a second payment. I'm not going to do it. And so then the district court, as well as this court, looked at the plan administrator's review of the plan term lump sum. Wasn't looking at the quadro language, was only looking at the plan interpretation. So the quadro issue didn't really even come up in that case. Again, the correct standard is a de novo standard, and the reason is that in the U.S. Supreme Court's Firestone case, where it said that a plan administrator may be given by the plan an abuse of discretion standard, the reasoning for that, as this court has said as well, is because the plan administrator has some special abilities to interpret the plan, is used to dealing with the plan language. You want a consistent interpretation of the plan document. So therefore, an abuse of discretion standard could be given in that case. On the other hand, when we're looking at a DRO, the domestic relations order, that's a state court judge's order. the plan administrator has no special powers or no special abilities with respect to interpreting those. And that's what the district court here said, and it cited the Fifth Circuit's Matasaran case, which held as well. And then the other cases that we cited in our brief, there's a trio of cases from the Third Circuit, Matthews, Hullett, and then Gruber. Those all held the same thing. And then there's an Eighth Circuit case. This wasn't in our briefs. I just found it when we were doing our research to prepare for argument, but it's Hogan versus Raytheon. So to my knowledge, all the circuit courts that have looked at this have said yes, because the Firestone case deals with plan interpretation, not a DRO interpretation. There is no reason to defer to the plan administrator. Rather, it needs to be a de novo standard.
So you're saying that the standard review is split with respect to the ERISA, the interpretation of the plan. ERISA tells us there's discretion, therefore we review under an abuse of discretion standard. And with respect to the question of the interpretation of the quadro itself, we review de novo.
Yes, that's correct, Your Honor.
Thank you.
Yes. And so I don't think the Fox case kind of really addresses the specific issue here, but it does dovetail nicely, because turning to the second issue that I wanted to talk to the court about, which is the plan administrator's, the district court's review of the DRO and the error it made in not applying North Carolina interpretive methodology for a contract. In this case, the plan administrator didn't interpret it. It decided just to rewrite the order for the judge. The plan administrator is not allowed to do that. Now, if you go back to Fox, you see what actually should have happened. In Fox, the second time that the participant came back to the plan administrator said, I'm not going to qualify that. I am stamping it as not qualified. That's what a plan administrator does with respect to a DRO that's presented. It either is a quadro or it's not a quadro. If it's a quadro, meaning it meets the requirements under ERISA to be a quadro, including that it does not require any type of benefit or form of benefit not otherwise provided by the plan, or that it does not comply with the plan in some other way, then the plan administrator says, yes, it's quadro, stamps it. That's what happened here. They stamped it and said, this is a quadro. It's good. There is no contradiction here.
Is that because it gives the plan administrator discretion because it uses the word may as necessary?
Okay, that gets into the actual language of and the interpretation of that quadro, which we are saying is a de novo standard of review. So again, the plan administrator does not have any authority to rewrite that order, but looking at the interpretation of that language, and I wanted to quote this for the court, here's what the language says. The alternate payee's benefit may be reduced as necessary to cover the cost.
But can you tell us what paragraph you're in are you in paragraph 4?
I'm quoting from Joint Appendix 824, that was the page.
Okay,
And
so paragraph 13.
I believe that's correct, Your Honor. It says the alternate payees, and that's the David's ex-spouse, benefit may be reduced as necessary to cover the cost of the QJSA awarded to the alternate payee. And so then the question is, yes, what does that language mean? And as Your Honor is asking, well, it says may. How should that be interpreted? And so under this, ERISA does not preempt state law. ERISA, as Your Honors are aware, has a very broad preemptive effect, but it specifically does not preempt state law. Rather, in interpreting quadros, the court uses the law of the state where the quadro was entered. That's because here it was a North Carolina judge entering a North Carolina order with respect to a North Carolina family law case involving North Carolina parties. Family law is traditionally an area where state law has applied and where federal law would not apply. That's why ERISA exempted it from any type of preemptive activity. So here, the court should have used North Carolina interpretive methodologies to determine what a contract means. Unfortunately, the district court did not do that. It simply looked at the word and said, well, I think it might be permissive, and so I'm going to uphold the determination of the plan administrator and decide that it can be permissive. That doesn't work under North Carolina law. North Carolina law says to interpret.
So North Carolina law says may means shall?
Exactly, Your Honor. Yes.
Even when shall appears over and over and over again in the same document? That's what North Carolina tells us in interpreting contracts, not interpreting statutes, in interpreting contracts.
I believe it does, Your Honor, and let me tell you why. It's because the North Carolina, in interpreting contracts, North Carolina looks to the intent of the parties. That is, as the King case in North Carolina says, that is the polar star, that is the sine qua non of what we're trying to determine is what was the party's intent.
Doesn't it only look to the intent when the language is ambiguous and can be interpreted different ways?
I think it would look to the intent irrespective. That's what the North Carolina law, the Supreme Court case, again, the King versus Davis case says, in all cases, we're trying to determine intent. We certainly would look at the language of the parties, and if the language is unambiguous, maybe that tells us what the party's intent is. But I think the intent is broader, and here may is ambiguous. The reason is, if you look at the full construction of the contract, North Carolina says you can look at the dictionary definitions, you can look at all the language used in the contract. You should look at whether one
Well,
interpretation.
and if we look at all of the language in the contract, there's places in the contract where it says shall, and here it says may.
Correct. Yes, Your Honor. And so let me address that. So just to finish with respect to that first thought, the dictionary definition says may mean shall. This court has held that may mean shall. And just to provide the court the site for that, it is United Hospital Center versus Richardson. There the court construed, it was construing a statute, but it said, we need to look to the intent to determine whether may means shall. And in that case, they ultimately held that the word may does mean shall. To answer Your Honor's question, yes, there are two different uses in there. In one place, the court's, the contract, the judges, state court judge's order says shall. In the other place, it says may. Here's why that may be, and we don't know. Unfortunately, the judge is retired, so we don't exactly know. The judge was trying to enter an order, a DRO, that would take effect many years down the road, a decade down the road. In this case, David actually was lucky because he was able to go ahead and receive his benefit early because of some corporate issues that went on with DuPont. But the judge had to make a decision and decide what to put in there. In the administrative record, it's very clear that the company was paying or could pay part of the cost of the QJSA. That's what we're arguing about, the QJSA cost and who would end up being, would be responsible for those. The company paid for part of those. So it makes sense that the judge would have said, the company may end up covering this cost. If so, fantastic, then neither party has to bear it. So the alternate payee may have that cost, maybe she wouldn't, because the company may end up covering the full amount of that. The company's covering part of that, and that's clear from the administrative record here. The other interpretive methodologies that the North Carolina court would use would also look to ERISA and say, if you allow may, here's the problem. That makes it totally at the unfettered discretion of the plan administrator. That's illegal under ERISA, because the plan administrator, as the appellees have admitted in their brief, the word may in there, interpreting it as permissive, says they could put some, none, or all of the cost on the appellee and opposite on David, the appellant. That isn't allowed because ERISA says you have to put in the quadro exactly what the determination is. How much is each party going to get, or some type of ability to calculate that. You can't calculate that when it's at the unfettered whim of the plan administrator. So yes, it's a bit awkward, but because of those additional qualities, the judge may be wanting to control for, perhaps the plan administrator is going to pick that up. But construing it as permissive violates ERISA, violates the fact that it also doesn't say the participant's benefit may be reduced. It only just says the alternate payee's benefit may be reduced. So it violates every other canon of North Carolina law construction. The only way to construe it consistent with North Carolina law is to construe it as that it puts the burden of the QJSA, the cost of the QJSA, onto the alternate payee. At worst, Your Honors, and we believe that this court, and we're respectfully requesting this court, grant summary judgment or reverse the summary judgment to the plan administrator, grant summary judgment in favor of David with that holding. At worst, though, Your Honor, we would say that under North Carolina law, if you apply these rules and it still has some ambiguity to it, then that should be a trial. And so we would say that at that point, the court would have to sit as trier of fact and to make a determination as to what the parties meant. I briefly want to touch on the third argument.
Let me ask you one question. So if we were to agree with you on your interpretation of the phrase, the may phrase versus the shall,
Yes.
would we need to determine, or wouldn't, at some point, someone would need to determine if the quadro conflicts with the plan, right?
The plan administrator has already done that. The plan administrator has already stamped the seal of approval and said this does not conflict with the plan. And they haven't pointed to anything in the plan, Your Honor, that conflicts with it. There's nothing in the plan that they've cited that shows that there's any conflict. And in fact, we quoted the legislative history of the Retirement Equity Act, which was where these quadros came in. It says the plan or the alternate payee or the participant can
But
have
doesn't the
that.
plan administrator say that that was part of the determination that May was permissive? Was because of the interpretation, because of this conflict with the plan?
But the plan administrator then is, again, that kind of gets back to my original point. Plan administrator then is rewriting the quadro. If the plan administrator thought there was a problem, then the correct thing to do was to stamp no and say this is not a quadro, you conflict with the plan. But the plan administrator has not cited anything. They've cited an SPD, some examples in an SPD. The SPD is not the plan. The plan is what gets enforced under 502 and under the Supreme Court's authority in Cigna versus Amara. All the examples they cited too are all married participants. They're not divorced participants. And I'd be happy to finish up if there's any additional questions, but I see my time is up.
Thank you. You have 5 minutes reserved, so we'll.
Thank you.
Thank you. And it's is it Wozniak?
Yes, Your Honor.
All right, thank you.
Thank you. I'm Todd Wozniak with Holland & Knight. We represent the defendants' appellants, or excuse me, appellees in this case. This is a pretty straightforward benefits claim. The quadro, or the DRO in this case, was qualified as a quadro based upon the plan administrator's interpretation of the DRO and its understanding that May is permissive. My colleague would have you come to the conclusion that somehow the plan administrator rewrote the order. There's no rewriting of the order. There was an ordinary reading of the order and then an application of that order to the plan and the plan's terms. Nothing unusual about this. At the district court level, the defendants did argue for an abuse of discretion standard for all of the determinations involved with the DRO and qualifying it as a quadro. The district court did not apply an abuse of discretion standard across the board. Instead, it applied a de novo standard for the quadro and then applied abuse of discretion standard for any plan interpretation or eligibility determinations, which is what my colleague is arguing for. The district court already did that. The district court also analyzed the decision-making, the entire decision-making under both an abuse of discretion and a de novo review standard, and came to the conclusion that the plan administrator's decisions were reasonable under either standard. So our position is there's no reason to send this back. There's no reason to remand this. The district court has already done the work. And I disagree strongly with my colleagues' arguments about the interpretation of this order. As the court pointed out, the order throughout uses the word shall when the family court wanted to make something mandatory. It knew how to use the word shall. It knew how to use the word must, mandatory. That's not what this provision says. The provision says may, and that is discretionary. And contrary to what my colleague is arguing, that does not make it illegal under ERISA. The plan has formulas for determining how a QJSA is going to be calculated and how that's going to divide up the benefit. And the plan administrator explained that methodology to the plaintiff here on multiple occasions. Nothing unusual about that. And it doesn't have to be an exact number. It's a formula that's required by ERISA. How are you going to calculate this? And the plan provides for survivor benefits, which would include the QJSA, of 50% or 75%. And then it talks about how to calculate that. And yes, some of the examples involve married people, but it doesn't change the calculation. The plan and the SPD explain how the calculation's made. And again, I will concede that the plan document is the controlling document, but the SPD is the plan administrator's interpretation of that plan document. And so the plan administrator, through the SPD, is putting out its understanding and its interpretation of the plan document and how these calculations are going to be made. So this is the common sense layperson's way of understanding what does the plan say about these types of benefits.
So
And
you disagree that if the quadro permits some level of discretion to the plan administrator, it's void or unlawful because it conflicts with ERISA? You disagree with that fundamental proposition?
Wholeheartedly, yes. And as the court pointed out, the opposite is actually the case, that in this case, the plaintiff's interpretation would actually cause a violation of the plan terms. And ERISA does not allow a DRO to require forms of benefits that are not provided under the plan. And that's what the plaintiff here is arguing for, is a form of benefit that's not allowed. Now,
Why would that benefit not be allowed?
because the Quadro rules specify that a DRO cannot order a form of benefit that the plan does not already provide for. And so in this particular case, if the so-called cost of this benefit, and there's really not a cost, there's an actuarial adjustment to address the fact that this benefit, this lifetime annuity benefit, is no longer going to be paid over the life of one person, but over the lives of two persons. And so there's an actuarial adjustment to account for that. And that's what everyone's been referring to as the cost.
So if it's not a cost and it's simply an actuarial adjustment, why do we even need to reach this paragraph 13 language at all? Can't we simply find that the actuarial adjustment was properly conducted and there were no costs?
I believe, Your Honor, that the answer is yes, because the court, the family court who entered the DRO knew very well that it was ordering a QJSA as part of the marital separation of property. And the family court presumptively knew exactly what that meant in terms of we're going to split the benefit up, part going to the husband, part going to the spouse, and there's an actuarial adjustment that's going to have to be used to calculate that amount. And throughout this DRO, the family court says over and over and over again that the court's awarding survivor benefits in the form of a QJSA. So, yeah, I mean, my view of this order is it's crystal clear. The family court ordered a marital separation of property, ordered a QJSA, and then said if there were some costs associated with that, and there can be costs associated with it. For example, if the plan goes and buys an annuity, there's a cost typically associated with that. You're paying an insurance company some fees in order to issue the annuity. Here, there was really no costs. As I said, the so-called cost that the plaintiff was referring to was really just the actuarial adjustment, to adjust from a single life annuity to basically a joint life annuity.
But there is, if we were to, considering opposing counsel's argument, if we were to consider North Carolina law, since we're looking at contract, this notion of looking at the intent of the parties, I mean, it does seem somewhat, I mean, there is some intent that the QJSA in these negotiations with Mr. Gasper, and I guess his ex-wife, was that she was supposed to pay the difference in the cost of the annuity.
Well, that's Mr. Gasper's very self-serving statement, that that's what the party's intentions were. That may have been his intention. We don't know. He wasn't deposed. But the wife didn't provide any testimony, and the family court didn't provide any testimony. What's in the record is that Mr. Gasper's attorney teed up a proposed DRO. The ex-wife's attorney teed up a proposed DRO. According to the record, the family court chose the ex-wife's version of the DRO and then made changes. And we don't know exactly what the changes were. So I would argue it's not the intention of Mr. Gasper that makes any difference here. He can have whatever intention he wanted. It's the intention of the court, the family court, in agreeing to this, the final agreement and making whatever modifications the family court made and then entering the order. So from my perspective, the way to interpret this is to look at the plain language. In North Carolina law, just like most states, says that you try to divine the intention of the parties from the words they actually used. You look at the contract. And in this case, the contract is pretty unambiguous. It says may. It doesn't say must. It doesn't say shall. We know the family court knew how to use mandatory words like shall, because it used it throughout the DRO. And it didn't choose to use that type of words here. It said may. I would argue the district court should have applied an abuse of discretion standard throughout. when a plan administrator is receiving a DRO and attempting to qualify that, it has to read the DRO. It has to come to an understanding of what is being ordered here, and then making a decision that based upon that interpretation, is it qualified or not?
But doesn't the case law say that the quadro needs to be reviewed de novo or interpreted?
There's nothing in the Fourth Circuit that says that. There has been some out-of-circuit cases cited by the plaintiff for that proposition.
Is there any case in any other circuit that goes along with your interpretation or your
Well, the court asked about
argument?
the Fox versus Fox case, and and although the court there, the Fourth Circuit there, did not explicitly say we're going to apply an abuse of discretion standard of review through the whole process, it certainly is implicit in the court's order there. And the court held that the application of the DRO in that case to the terms of the plan were in fact subject to an abuse of discretion standard review. Now, the panel there did not make crystal clear, are we applying it to just the interpretation of the plan? Are we applying to the interpretation of the quadro, or both? But certainly implicitly, the abuse of discretion standard was applied to both. That I think is probably the closest that we found on that issue, particularly in the Fourth Circuit. But again,
If we were to agree with you, though, we would be creating a circuit split, would we not?
the circuit courts that are relied upon by the plaintiff involve where the sole issue is the interpretation of the quadro. And that's not what we have here. It's not a sole issue involving the interpretation of the quadro. The quadro still has to be applied to the plan, and the benefit still has to be determined. And so there is kind of this mixed construction, if you will, of both the quadro itself, but also then how does that apply to the plan in terms of the plan options for optional forms of benefits, and then how does that get calculated? So in my mind...
Do we have to agree with you in order for you to win?
No, you can just agree with the district court. The district court clearly said that it was reviewing the quadro under a de novo review standard and applied that de novo review standard and determined that the quadro was unambiguous and that may means may and not must. And I think you can just simply affirm that ruling. Now, there was a issue that was raised by my colleague about the affidavit or declaration by Mr. Gasper and whether it should have been considered. The 502A1B claim, the claim for benefits, the standard in this circuit clearly is if it's not in the administrative record, you don't consider the evidence unless there's some extraordinary circumstance. He's presented no evidence of an extraordinary circumstance. As to the 502C claim, which is a claim for statutory penalties for alleged failure to timely provide plan documents, the district court has discretion to award penalties or not award penalties. And the district court here found that the plan administrator, if not fully complied, certainly largely complied with the request for documents. And one of the biggest issues that Mr. Gasper presented was, he said, I wanted the 2008 summary plan description, including various summaries of material modification, which are basically just amendments to the SPD. And in this case, the record evidence shows that he was provided the 2013 SPD, which is the SPD that the plan administrator determined was applicable. And the 2013 SPD includes everything in the 2008 SPD and all of the SMMs. So this argument that there were some documents that he didn't receive is really not true. He received the operative summary plan description, and he was told that this has the language that would have applied, including all of the SMMs. And so, as the district court found, he received virtually all of the documents he asked for. Now, he claims that there were a couple pages missing from an appendix to the plan. We don't know for a fact that's true or not true. We've just kind of taken that as true. And of course, as soon as he brought that to our attention, he was provided another copy with the appendices intact. But what the district court found was that none of this prejudiced Mr. Gasper because he completed his appeals process. He filed his second level appeal prior to ever asking for the plan documents in writing. And prior to asking for the plan documents in writing, the plan has no obligation to provide him anything. In this case, though they did, on oral request, the plan administrator in fact sent him plan documents and sent him the SPDs and sent him everything else that they thought was responsive. So in this case, the district court exercised its discretion and said, that's substantial compliance. I'm not going to impose a penalty. And there's nothing in the record to suggest the district court abused its discretion in that regard. The last claim is an attorney's fees claim. That really rises or falls on the merits of the other claims, and so I'll leave that issue alone. It's going to obviously depend upon how the court rules on the primary claims of the benefits claim and the 502C claim. I would make one other point. In the appellate brief, there's a number of statements where Mr. Gasper asserts that the plan administrator abused its discretion and actually breached its fiduciary duties. There was a fiduciary duty claim in this case. It was dismissed on a motion for judgment on the pleadings, and that decision has not been appealed. So any alleged breach of fiduciary duty is really off the table. That's already been dismissed and eliminated. Do you have any questions for me?
Any questions? All right, thank you.
Thank you.
Yes, sir, Mr. Tyson.
Yes, I wanted to rebut a few of the statements made by my colleague. First, they did rewrite the quadro, or the DRO. There's no question about that, because in the determination report, they said, well, we're going to rewrite this for you. We're going to say it's the total monthly benefit that we're, not the alternate pays benefit. We're going to rewrite it and write total monthly benefit shall be reduced. Total monthly benefit isn't defined anywhere in the plan, anywhere in the SPD. Then they came back and said, when David appealed that and said, hey, I think you guys got this wrong, they came back then and said, well, we qualified the quadro, but what we did is we just ignored that language in there. Again, you don't get to rewrite a state court judge's order. You don't get to decide that it's different language or ignore it. It's either a quadro or it isn't. And then they came back a third time and said, now we're going to interpret it and say it's permissive. So they've had three different ways that they're trying to come up with a way to get where they want to, but they absolutely did rewrite the state court judge's order. They did not just interpret that. The second, does it make it illegal? I think Your Honors had asked, does it make it illegal if it's permissive? Absolutely it does, because then, again, the plan administrator could say, I'm going to impose all the cost on David. He gets what he currently has. If they said, well, it's permissive, so I'm going to choose to impose none of the cost on David, he's going to get a different amount then. That's going to vary that quadro, and it's willy-nilly at how much they determine. There's no standard for what the plan administrator would be able to do. They can choose whatever they want. That is not a valid quadro because it does not have a formula or a set standard as to who's going to get what. Totally at their whim. And then the other point I wanted to make with respect to that, as far as violating any plan provision, again, they have yet to cite a plan provision that is being violated. There's nothing in the briefs, also in the administrative process that my client went through by himself. They're supposed to give him, when they send him a letter and say, hey, we're denying your claim, as one of the ERISA claims regulations requirements, they have to say, here's why we're denying it. Here's the plan provision on which I'm relying. Nothing in there. Nothing. So if they're going to cite a plan provision, they need to tell him what it is.
I thought he said that the plan did not allow for the alternate payee, the structure that you were.
There's nothing in the plan that doesn't say the alternate payee can't pay this. ERISA law allows that to happen. How can something be violated when ERISA allows that? And the plan doesn't contain that. The only thing they've cited is that 2008 SPD that has examples of a married participant. Here's why that doesn't really help them. A married participant, you've only got one payment coming out. There's only one payment when somebody's married. And so the QJSA has to come out of that one payment. There's no other place for it to come from. On the other hand, with David or with a divorce participant, you have the participant, and then you've got the alternate payee. There's two streams of payments that are coming out, so it would make sense that it could come out of either one of those. Nothing in the plan, nothing in the SPD prevents that in a divorced participant case. They've cited nothing. They need to cite something if they're saying it's actually violative. And if it is violative, how did they possibly qualify it? You can't do that. That isn't possible. So the plan administrator, if it thought that it was violative, they should have stamped, no, this is not a quadro, go back and fix it. And that's the problem. If they had let David fix it, if they had said this isn't a quadro, we think it's a problem, then he could have gone back, they could have redone the divorce, but he relied on this. He thought, okay, great, you're going to pay for it, therefore I'm going to take these other positions in my divorce as far as, anything else, any other types of equitable distribution issues.
Well, counsel, let me ask you something that's confusing me a little bit. Is
Yes, ma'am.
actuarial adjustment a cost? What is your position on that?
Absolutely, thank you, I'm glad you asked me that. I did want to turn to that. Yes, it is a
Okay, well, the
cost.
district court cited the plan summary, did it not?
I believe it, I believe it
Regarding
did.
the cost of the annuity?
Yes, here's why it is though. Here is the
Okay.
quadro guidelines that they give out to people and say, here's some general information that may help you draft your quadro. Here's what they say at JA 530. Here's what the plan administrator says. The accrued benefit may be reduced as necessary to cover the cost of the QJSA awarded to the alternate payee. The plan administrator itself is calling this the cost. And I will also cite to your honors JA 560, the correspondence. They specifically reference cost. JA 188, the determination report of the participant's benefit commencement date, the total monthly benefit will be reduced to cover the cost. They label it as the cost. Those are one and the same. We would respectfully request that Your Honor reverse the summary judgment grant and remand this to the district court for further proceedings consistent with our arguments. Thank you, Your Honors.
All right, thank you. We will step down and we will take a short break. We will take, right after we step down and greet counsel.
This honorable court will take a brief recess. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Thank you. You may be seated. All right, and our next case is 24-1793, Deborah Sheldon versus Allergan Sales LLC, and we will first hear from Mr. Callow.
Yes, Your Honor.
Yes.
Good morning. Thank you. May it please the court. My name is Joe Callow of Callow and Utter. I'm one of the attorneys representing Ms. Sheldon in this litigation, and I'd respectfully ask for 4 minutes of rebuttal time for my argument.
Yes, sir.
Thank you. Your Honor, we're here on a decision where there's not much agreement between the parties, but the parties do agree that the district court's analysis was flawed in this case. The district court simply got it backwards and didn't do the proper analysis required in a False Claims Act situation. In most False Claim Act cases, the court determines falsity and then determines scienter. In this case, the district court punted on falsity, saying both sides could have plausible interpretations of the statute, and because both sides were plausible, you cannot have scienter as a matter of law. Those are the two errors that we bring forth here today. First and foremost, the court cannot punt on an ambiguous statute. The court has to interpret an ambiguous statute and determine its meaning. And secondly, scienter of an ambiguous statute does exist. You cannot say there's no false claim as a matter of law. In fact, the Supreme Court in Schutte versus Supervalue said the exact opposite, which is why this case was originally sent back from the Supreme Court to the district court to deal with scienter under Schutte versus Supervalue. Unfortunately, the district court did not do so. So in this case, the district court's analysis was flawed on both points. What we would argue is that this court needs to determine what it means under the rebate statute and the rebate agreement, and how to calculate the best price. And what the court failed to realize is that that requires a manufacturer who signs a rebate agreement, who voluntarily, year after year, agrees to calculate best price consistent with the terms of the rebate agreement, who agrees to use the best price actually realized, has to combine rebates given to wholesalers, retailers, insurers, and the like. Forrest, as we allege in this case, did not do so, and did not do so intentionally because they had a scheme to increase their business at long-term care pharmacies. And Mr. Sheldon knew this because Mr. Sheldon had worked for the company for 20 years. He was in sales. He managed other salespeople as well. He dealt with these contracts, so he knew about the strategy to try to get more business from long-term care pharmacies. And what they did to grease the wheels was to give multiple rebates on the same pill, to get that pill into a formulary, to get it prescribed to a beneficiary. So they intentionally, deliberately gave 2 rebates for the same drug unit in order to advance their sales. But when they reported best price to the government, they only included 1.
So your operative complaint relies pretty heavily on the CMS proposed rule and comment in 2006, 2007, that time period. So do you agree that the claims that Allergan submitted without the PBM discount before that period can't properly be considered to have been submitted with the requisite intent?
No, Your Honor, because the best price statute goes back to 1991, and there are program guides in both 1991 and 1994 that determined that the government wanted the best deal at the entire time. It engaged in rulemaking in 2006, 2007 to confirm it, but the problem goes all the way back to 1991 when the best price statute was first enacted. CMS has gone through multiple rulemaking in 2007, in 2016. They proposed a new rule in 2023 that specifically identified the district court's opinion and said they disagree with the district court's opinion. It can't be any more clear than when CMS writes a rule and says, we are aware of the Sheldon District Court opinion, it is wrong.
Well, perhaps it became clear in 2023, but before that it was not clear.
It
So
was
how could
clear-
you have a false claim if the rule isn't clear?
So there's a false claim going back all the way to 91, but in 2007, the rulemaking progress specifically said that you have to aggregate the rebates to two different entities. And they did it again in 2016. And in 2023, CMS says, we told you in 2007 not to do it. In fact, in the record.
Now, when you say they're saying, you're saying CMS said you have to aggregate the rebates, what is your basis for that in the record?
In the record, we would have this language of the best price statute, the language of the rebate agreement year after year, which talks about prices actually realized and talks about how to calculate the best price. We have the 2007 rulemaking, Your Honor, which includes a letter from Forrest saying that we are concerned that your language requires us to aggregate.
Right, and then CMS responds, we do not agree.
We do not agree. That's exactly right, Your Honor. We do not agree. And they continue not to change their policy.
So how is that legally binding? And that's what I'm interested in your position on. How is that legally binding on Forrest? We do not agree.
Because it warns them away from their interpretation, which is a factual issue under the Sienter analysis, where CMS is saying, we are requiring you to stack. The example given was a rebate to a wholesaler and a rebate to somebody else, and Forrest said, hey, we're concerned you want us to aggregate those. And CMS says, yes, we're not changing the language. We are not going to change the policy. You are interpreting it correctly. And they don't do anything. They don't contact CMS. They don't write another letter. There's nothing in the record that they did anything differently.
I thought CMS's example in that instance dealt with a rebate, a double rebate to a wholesaler, one up front and then one after the fact. Is that not correct?
The comment, Your Honor, it's on
And
page
give me a record site, and that'll be the best way, I think.
JA 57 through 62 is where we cited in our complaint, and it's 72 Federal Register 39199. The example is one commentator requested that when best price is determined, customary prompt payment discounts extended to wholesalers should not be aggregated with price concessions available to an end customer. Two different entities. And it says that they're concerned about aggregating, and the response is, we do not agree. Both the customary prompt pay discounts and other price concessions available to the end customer are to be included in the determination of best price. A rebate to a wholesaler, a rebate to an end customer, you have to combine them for best price. That's the specific language in 2007. That language occurs in 2016 and occurs in 2023.
Okay, we're not considering 2023, are we?
I think we're considering 2023
Why?
because, one, the allegations in our complaint go to the present. So even though our complaint was filed several years ago, we have multiple allegations that our claims go to the present. So 2016 and 2023 are relevant. Second, the 2023 analysis from CMS specifically says that it has taken this position consistently since the 2007 rulemaking. So if there's any doubt about what happened in 2007, CMS tells us we told them to stack in 2007. That's CMS's position. And so it is relevant to confirm the historical nature of where we are.
Okay. Now let me ask you about CMS's wholesaler example. Judge Hollander said, didn't she, that CMS example ultimately dealt with the wholesaler in both respects? In other words, that there wasn't a separate entity in that example?
She interpreted it that way, Your Honor. You're absolutely right.
Why was that wrong?
Because
Or was that wrong? Do you agree?
I believe it was an error, Your Honor, because the example in the language I just read talked about wholesaler and end user, and CMS specifically says combine both of them. Those are two separate entities.
But she said that, in her analysis, she said it was the same entity. It only dealt with the timing of the payments, didn't she?
I think that's an error, Your Honor, and that goes to the idea.
But are you agreeing with me that that's what she said?
I agree, Your Honor.
Okay.
She also said that the statute was helplessly ambiguous and there's no way to clear it up. Well, That's what courts are for, to clear it up, to tell us what an ambiguous statute means or doesn't mean. That is the role of the court, and you can't punt on that. So this court has to deal with what that statute means. On one hand, then let me be clear, under the False Claim Act claims under Rothschild in this circuit, all I have to do is pose a plausible theory of liability. I have to establish a plausible claim of falsity and plausible allegations of scienter.
Well, what is a plausible claim? You have to take the inferences in the favor of the plaintiff,
Absolutely.
and they could support a claim.
Absolutely.
Okay, what else do you need? Anything else?
That establishes me on falsity, and then I need to have allegations of scienter under Schutte versus super value, whether it's reckless disregard, deliberate ignorance, or actual knowledge. We've got pages of that in our 179-page, 879-paragraph amended complaint. So the district court says we plausibly pled, but then it threw up its hands and says, well, maybe Forrest plausibly pled. I can't make that determination. At the motion to dismiss stage, it doesn't matter. I should survive a motion to dismiss by construing the facts in a light most favorable to my complaint and construing all inferences in a light most favorable. That's one of the problems we face when we read their brief and it says, well, we made reasonable inferences. We made reasonable assumptions. I don't know what those were. There's no record of those. There's nothing in the record before this court that says what the reasonable inferences or reasonable assumptions were, because that's a fact issue.
But the rebate agreement, you agree, the rebate agreement does allow the manufacturer to make reasonable assumptions.
It does, Your Honor.
And your point then
and
is that allows you to carry forward to summary judgment because that is something that needs to be determined factually?
100%, Your Honor. The rebate agreement says in the absence of guidance, a manufacturer can make reasonable assumptions and has to keep a record of them. And it's important that that record is either written or electronic. One, we think that there was guidance that warned them away from what they were arguing, as we identified in our complaint. Two, I don't know what those reasonable assumptions are because we're at the motion to dismiss stage and they haven't produced the written record of what assumptions they made. And most importantly on that, I don't know when the assumptions were made, when or what, because what assumptions were made after 2007 rulemaking or after 2016 rulemaking or with respect to the 91 and 94 guidance, all of that matters.
It does seem unusual to have a case come to us on a motion to dismiss with such a voluminous record of documents that are outside of the complaint. I will grant you that. I have a question about how we should even consider these CMS guidance from the various years post-Loper-Bright.
Yes, Your Honor. So Loper-Wright, this court's issued a number of Loper-Wright decisions over the past several months. Loper-Wright still says that we can look to CMS for guidance, and if it's consistent and thorough and within the statutory delegation, it's still appropriate to look to CMS.
But is it evidence of scienter? In other words, going against a CMS position
So I would say that
after Loper-Bright?
So I think Loper-Bright deals with the falsity issue, Your Honor. It deals with what is required under the statute and how this court should interpret the statute.
But wouldn't it also deal with with scienter?
Well, scienter, I think, is more of a Schutte super value and a factual allegation and a warned away allegation. Because we first need to establish what the statute allows or what the statute requires. And we would argue that even post-Loper-Bright, the CMS rulemaking is entitled to greater deference, greater respect than most other type of guidance talked about in Loper-Bright context. And the rebate agreement is different because the rebate agreement's a voluntary contract. The rebate agreement is not required by statute. They don't have to sign it. If they don't want to do business with the government, don't sign the rebate agreement. But if you sign the rebate agreement, you're required to comply with it. And that's complying with prices actually realized and combining in all the rebates that are appropriate. So I think Loper-Bright helps us with falsity to determine how the statute is read. Factual allegations in our complaint deal with scienter.
How are we to interpret this price actually realized language that seems to appear repeatedly throughout the record?
So price actually realized talks about the focus on the unit, focus on the drug unit, and combining any rebates given to parties associated with it. And we would argue that that clearly means that any should be interpreted broadly, not narrowly, for any rebates between an insurer and a retailer, or a wholesaler and a retailer, or in this particular case, the retailer pharmacy and the retailer insurer to get that pill into the long-term care pharmacy. I mean, in this particular situation, as we allege in our complaint, Forrest made a conscious decision to increase its market share at long-term care pharmacies and had to give more than one rebate to do so. So the price actually realized for it to increase its market share included both of those rebates, and that actual price realized is different than it had in other circumstances. But it didn't give the government that value. It didn't give the government.
So price actually realized is from the perspective of Forrest, not from the perspective of the purchaser.
Absolutely, Your Honor. And the price actually realized is on a per pill basis. In both the best price statute and in the rebate agreement, it talks about focusing on the pill, the unit, not on the transaction. When you read Forrest's brief, they talk about bilateral transactions, individual customer, single entity, lagged price concession. None of those words appear in the best price statute. None of those words appear in the rebate agreement. I've listened to arguments this morning talking about, well, what does the statute say? What does this mean? None of those words that appear throughout Forrest's argument are actually in the best price statute or the rebate agreement. Those talk about focusing on the unit. Any rebates that affect the price actually realized need to be included. And that's what CMS has told manufacturers for 30 years. The irony here is that Forrest is asking the court to interpret the best price statute, the rebate statute, to say it's never required stacking, even though all the manufacturers other than Forrest have listened to CMS say year after year after year, aggregate. They're asking for a get-out-of-jail-free card from this court to interpret the statute differently.
But don't we, I think at the same time that Forrest is asking questions, you have other law firms asking this similar questions.
Absolutely.
So
Everyone's
so
asking.
that would be indicative of there's some confusion or something, right?
Which is why Forrest got the answer in the response to rulemaking, not a guidance document, to rulemaking. And it's important to know what Forrest did afterwards. Did they change their policies? Did they say, screw you, we're going to go forward? And we don't know that in the record. What we do know is that my client alleged in the complaint that they intentionally and deliberately ignored that advice and continued to go down the path they wanted to. And they intentionally bypassed the DNA process that we describe in our complaint that would have caught these double rebates.
Well, you said, what did Forrest do? What did CMS do? They opine that they don't agree with Forrest and the other companies, but then do they change the definition? I mean, did they change the rule, excuse me?
They did not change the statutory definition. They did not change the language of the rebate agreement.
Right.
Everything stayed the same.
Okay.
So they told the manufacturers, here's what we believe.
That's our interpretation.
Absolutely, Your Honor. That's correct.
Okay, I guess what I'm having trouble is leaping to the point where CMS has given its interpretation. Why is Forrest then violating the law by not agreeing with that interpretation?
Because it's a false claim when they don't submit their claims with the proper best
Okay.
price calculation.
So what is the falsity then?
The falsity is not aggregating the rebates.
It's not agreeing with CMS's opinion. You're saying failure to agree with CMS's opinion constitutes a falsity?
No, Your Honor, I'm saying that the best price statute and the rebate agreement required aggregation. CMS confirmed that in their rulemaking, and it's a violation of the statute and the rebate agreement to submit best price calculations to CMS on a quarterly basis that did not aggregate those claims. That's the false claim. And the scienter is they did it intentionally with actual knowledge and reckless disregard for what CMS said, even though they were warned away, and we allege that in the complaint.
Can you, where in exactly do you allege that Forrest knew to aggregate the multi-entity concessions? Where in the, and if you can give me the JA, that would be great.
So it would be in the references to the DNA, which are paragraphs 69 through 71.
Which pages in the JA?
JA 69 through 71. And then we also reference that actual knowledge and deliberate ignorance are on multiple pages.
But more
Is
than
that-
just the inference, but where are the specific allegations that, to show that Forrest knew to aggregate?
Well, in our complaint, we go through all of the CMS guidance, and we talk about all of the CMS guidances in 07, 2016, and we talk about how CMS told them. So when we talk about the 2007, the response back that I just read, JA 57 through 62 are the pages in our complaint where we specifically talk about the 2007 rulemaking process and the letter from Forrest to CMS, and the CMS response on the commentator is JA 62 as well as 72 Federal Register at 39199.
All right, thank you.
Okay, could I ask
Oh,
just
sorry. Yes.
one other question? How does the fact that Forrest, in your allegations, claimed allowed two rebates in some situations and only one in others, right? How does that show Forrest's motivation to avoid a best price violation rather than Forrest's interest in simply maximizing its profits?
Forrest has every right to maximize profit, increase business, come up with marketing schemes and pricing schemes, as long as they give government the best price. Because the whole fundamental basis of the Medicaid rebate statute and the Medicaid program is that the government always wants the best deal. So if Forrest wants to increase business in long-term care pharmacies, it can do so. And it can play with its pricing if it wants to, as long as when it does that, it gives the same deal to the government. Because what it can't do is increase its business, change its pricing mechanisms, come up with cute deals or clever wording, and not give the government the best actual price realized under the rebate agreement in the statute. That's the fundamental flaw, because the government always wants the best deal. And if Forrest gives it to one company, it has to give that same deal to the government.
Any other questions? All right, thank you.
Thank you.
Yes, sir, Mr. Elwood?
May it please the court, John Elwood for Appellee Allergan Sales. This court can affirm the district court's judgment on any of the three grounds outlined in our brief. Relator, however, has to win all three of them. I'd like to focus on falsity and scienter. First, Allergan's statements weren't remotely false. During the first appeal, another panel of this court, the majority held that the the plain and natural reading of the rebate statute, which was actually language used by Judge Hollander, and that the best reading of the statute was that the best price entails the lowest price available from the manufacturer, including all price concessions to any one of the listed entities, but not to multiple entities. That's only, you only consider that for its persuasive value now, but I think that it's just as persuasive as it was back in 2002, 2003, I forget when it was. And nothing that has happened since, the vacatur for Schutte, which was a Sienter holding, none of that throws a cloud on that analysis at all, and I'm happy to walk through the court what that is. What Relator is trying to get is not the benefit of the best price. What Congress said is that the government should get the benefit of the best price, the lowest price that the manufacturer gives to its best customer. And what it's asking for here is not a price that Forrest or Allergan gave to any customer. It's asking for a net revenue figure where you cobble together a bunch of discounts along the chain and give it to, and basically, if we don't report that as the best price when it's not a price that anyone pays, we are guilty of a false statement, and that's just not the case. As the prior panel majority said, that is not a price available to any entity, it's a price available to no entity.
But it is the price actually realized.
I don't believe it is the price actually realized. It is the net revenue realized. If you look at the actual rebate statute, it defines the price as the lowest price available from the manufacturer to any wholesaler or retailer or provider or HMO or nonprofit or government entity. That sets up a bilateral transaction. I mean, you can't say you're going to accumulate little bits of discount from each of those entities when it says it's a price available from the manufacturer to any one of those entities. As the prior panel majority said, when you have all of those single nouns separated by disjunctive ors, it strongly advises against aggregating discounts to multiple entities. And it wasn't just the prior panel. We also cited the decision Gibbons versus Malone from the Second Circuit, where the Second Circuit said, when you're saying purchase or sale of any equity security, that's a singular term. You're not going to, say a purchase of this security and a sale of that security. You have to go basically entity by entity.
So you're saying the CMS interpretation that is exceedingly clear in 2016 is just plain wrong?
I don't think that, well, to begin with, 2016 is outside the era of the false statements.
Well,
because,
that's a Sienter issue, it's not a falsity issue.
Well, but first of all, the 2016 guidance, I think, is consistent with our interpretation. I'm happy to talk about that. But it's also beyond the period where they said we made false statements. They only allege false statements.
I understand.
Until
That's the
2014.
That's the Sienter issue.
Right.
On the issue of the interpretation of the language of the statute, that's the issue of falsity. On that issue, what's the relevance of the language of the 2016 language is very clear.
The 2016, I don't believe that the 2016 for falsity, I think Loper Bright is an answer for why the 2016 guidance isn't relevant to falsity. But I think that it's also,
So we just ignore it? We just ignore what CMS says about the statute?
I don't think we have to ignore it, but it doesn't alter what the statute says. An administrative agency can't change what the statute says, and our obligation is under the statute. But in any event, I don't think that the 2016 language is a problem, because you have to look at, it's not enough to just say, oh, well, they said we disagree. You have to see what they say after disagreeing, because every example given, and this is true of both, in 2016, it's 81 Federal Register at 5252 to 53, and there are two examples in the 2007 guidance, which is 72 Federal Register at 39,198 to 199. The same example is given for two of those. The 2016 is also in 2007, given to 2007. But it says what they focus on and why they're disagreeing is because the rebate to two entities, if that rebate flows to the other entity, that's when you count it. That's consistent with our opinion, that basically if you give a rebate to both of these entities and the one entity gets the benefit of both of those rebates because of how it works, yes, then that adjusts the price realized for that customer. And this is where you look at it, is they talk about where the discount is given to a pharmacy benefit manager, where the rebates are designed to adjust prices at the retail or provider level. So exactly as consistent with our interpretation, when that rebate to the pharmacy benefit manager flows to the retail or provider level, that's when you count them. That is consistent with the prior panel majority's reading and with the interpretation we explained to CMS, which is that basically when the rebates flow to one entity, that adjusts the price realized for that entity, and yes, you count that. But that is, again, consistent with our opinion. Imagine now if CMS had written that response in the way that, to show that it wanted to agree with the relator here. They would have said, of course you count the discount. You have this discount and that discount, you add them up, you put them together. But instead they specified you add them up when they flow to a single entity.
Well, Mr. Elwood, if CMS had given the 2023 response in 2016, had given the 2016 response in 2007, wouldn't your case be a lot weaker? And why not?
I disagree. I think the 2016 response is perfectly in accord with us.
Yeah, compare the 2016, where they pretty clearly said that double stacking has to be reported, didn't they?
No, and again, I was explaining I was reading from the 2016 comment there. They say when the discounts flow to one entity, that's when you count it. That's consistent with our interpretation. The relator's interpretation, it doesn't matter whether they go to a single entity or not. Merely because they're given along the path of the drug sale, you have to add them up.
But what I'm getting at, and maybe not doing too well, is that I think that your case is a lot stronger if you were just sitting on the 2007 response. But then I think your case gets more problematic when you get to 2016 response and the 2023 response. And so it seems to me that it's important for you to tell us why we don't consider 2016 and 2023.
Well, you don't consider 2023 because it was never even finalized. They put it out there as a proposed reading. Mm-hmm. And I think that this hurts them in two ways. First, it shows that the government knows perfectly well how to explain a relator's position. It knows how to say you got to stack discounts regardless of whether they're realized by the same entity. They know how to say that, and they didn't say that, not in 2023, not in 2016, not in 2007. I'd like to talk about the other example from 2007 that he said that my friend Mr. Callow says is so obvious. This is the example of the discount that is the two discounts that are achieved through the wholesaler, because they say you got to combine both a prompt pay discount to a wholesaler and then also another discount to the end customer that is done by a chargeback through the wholesaler. Now, as the panel said, this is at JA 286, and the district court in the first opinion at JA 252, or I guess I think that's the first opinion at 252. She also found it, again, in this most recent one, that when a prompt pay discount is like a $1 pill, you give it to the wholesaler for 98 cents. Then say down the road, you sell the wholesaler has to sell to like CVS or somebody at 70 cents because there's a separate agreement that says you got to sell to CVS for 70 cents. That is administered through a chargeback. So basically at that point, the wholesaler says, I had to give it to them for 70 cents, make me whole. And then the money goes to the wholesaler. And so they have both the prompt pay discount of 2 cents and the 30 cents or whatever to sell it at the 70-cent thing. Both of those discounts flowed through the wholesaler through the chargeback. We cited a 1996 case, INRI brand name prescription drugs antitrust litigation, where they recognized that chargebacks to the wholesaler operate as a discount to the wholesaler. And so this was already well established in 2007. So when we read this in 2007, we go, this is great. Both of these discounts, the reason why you're counting them is because they flow to a single entity. That is, again, consistent with our interpretation. If CMS was trying to say their interpretation is right, they'd say, you have this discount and that discount. You always add them up. But no, they specified you add them up when they flow to a single entity. That is our interpretation. Now, I think I also want to point out that it was not just us giving this interpretation to CMS, and they say we were on notice because we said there was language in a preamble. Preambles didn't even count before Loper Bright. Preambles weren't entitled to deference, or not Chevron deference, even when Chevron was good law. But we said that perambular language, we said, quote, the proposed rule, the actual regulation, not the preamble, must be interpreted to mean that associated discounts and price concessions are provided to the same entity to whom the drug was sold. We said that. Every other entity essentially in industry said the same thing. Pharma said that. And the most remarkable thing is, even though they said a lot of "we disagrees" during that, they never said "we disagree with that statement." And when you look at all of the CMS commentary to see what they're disagreeing with, their statements after that are all totally in accord with our reasoning. You count the discounts to different entities when they flow to a single entity. That's what we're talking about, prices actually realized. It's the price realized to the wholesaler when it aggregates the 2-cent prompt pay and the 30% lag discount that, from the chargeback. That's what it means to have prices actually realized. That's what we interpreted it to mean. And so I think we've been jumping around a little bit when we're talking both about the scienter, talking about the fact that we told CMS, and in fact the whole industry told CMS, this is how we read this statute. But there are other reasons why I think it's important to count it that way.
Your colleague says that the whole industry submitted their claims based on a stacked calculation. Everyone else did that other than your client, is that right?
I don't know where he's drawing on for that because, again, there's nothing in the complaint that I'm aware of on that. And it's in the record that Pharma submitted its own brief. He pointed out the fact that other people submitted similar letters to CMS. And so all we have from the complaint is that that every other every other manufacturer that he's talking about submitted the same kind of letter saying this is how we interpret our obligations. And the reason why that makes sense is because, as the prior panel said, the rebate statute talks about rebates that are available from the manufacturer to individual parties. And what Mr. Callow is talking about is not a price that's available to anybody. Nobody can say, add together all of these rebates and give me the drug for that price. Nobody pays that price. And in addition, when you look at the legislative history, this is what Congress said it wanted. It said it wanted to, quote, give Medicaid the benefit of the best price for which a manufacturer sells a prescription drug to any public or private purchaser, unquote. If you look at their most recent brief, they now are disclaiming, this is the relator's brief at page 20, they're now saying they don't want the lowest amount that any one particular purchaser pays. What they want is a net revenue figure that nobody pays. And that simply isn't what the rebate statute permits. Moving on to, let me see here. I think moving on to the scienter requirement, I think the important thing here to remember is that basically just pleading what our mental state was. I don't think you can say that we are plausibly guilty of willfully defrauding the government.
Well,
which
what's
is after
missing? What's missing from Sheldon's scienter pleadings?
What's missing is, for starters, he never says how we knew that this was false. He says we knew it from the language of the statute. And that's why the judge below went to such lengths talking about why she addressed falsity the way she did, because it's relevant to scienter. They said we knew because of the language of the statute, but that obligation is definitely not from the language of the statute. As I say, it's not even clear from the language of the regulations. It's also, I think, when you're talking about recklessness and willful ignorance or deliberate ignorance, one of the elements of deliberate ignorance that he has to plead is the fact that we were aware that we might be wrong, and we didn't take the steps necessary to clarify that.
Right.
We told the regulator.
Sheldon is saying that you were warned. Sheldon's saying you were warned in 2007, aren't they?
They are saying that, but we're saying that we took the step. It says right there in the pleading that we took the step to try to clarify our obligations. Instead of, being silent, which is what it is, it's an ostrich thing. It's not an ostrichy move to tell the regulator in print, this is how we interpret our obligation. That is taking a step to clarify what your obligation is. And
Well, the
so,
False Claims Act Sienter standard says reckless disregard for the truth or the falsity of the claim. It doesn't say reckless disregard for the falsity of the claim. How should we interpret the inclusion of truth or falsity as part of the Sienter requirement?
I think because we're telling the regulator, this is our interpretation of the statute, that will resolve what the truth or falsity is. We were seeking out guidance about whether our interpretation is correct. And that shows we were not trying to be deliberately ignorant about the truth or falsity of the claim. We're trying to find out what we mean, what the regulator interprets us to mean. We told them what our position was. As I say, they didn't tell us that our position was incorrect. And I think that addresses both deliberate ignorance, because we did seek guidance. That's not burying our head in the sand. That's us seeking guidance. And I think it addresses recklessness, which is the idea that we're taking an unjustifiable risk. And the risk is not unjustifiable when you tell the regulator, this is what we think. Are we right about this? And then they didn't say, that position is wrong. You got to accumulate, you got to stack discounts regardless of who they flow to.
It seems to me that Sienter and the Supreme Court has said this in Shoot is a subjective standard, which almost by definition means it's a question of fact. In discovery, there could be emails between executives at the company saying, let's submit this letter from a lawyer asking the question, then that'll satisfy the requirement that we've checked in to see if what we're doing is right. I mean, we have nothing, because all we have are public documents, a lot of them, but we have no depositions, we have no documents, we have no discovery at all, and yet we're being asked to decide what seems to me fundamentally a question of fact at a motion to dismiss stage.
But it's not a question of fact. The question is the adequacy of the pleadings. And Schuette was a case that happened at the motion for summary judgment stage after there was already evidence that the company there, Super Value, I think it was, believed that that position was wrong. And not only that, but there was also the decision that the position was wrong. The courts had already determined that. And so it didn't address pleading standards at all, but you still have to say, what did they plead? And all we have is a conclusory allegation that we knew it was wrong. Judge Keenan, you were part of the panel in Complin, unpublished opinion, but it said that the Complin court said that they have to do more than just a conclusory allegation that the decision is wrong. You have to, let me see here. An FCA plaintiff must set forth specific facts to support an inference of knowledge. And there they said there's no allegations about employee conversations or efforts to sweep stuff under the rug or anything like that. Mr. Callow has emphasized that the relator in this case was, worked at this company for 20 years, so it's not asking too much to say, tell us why you believe they knew that it was false. In addition to the only things they really point to, and this is at page 49 of their brief, to say that we knew that it was false were the language of the regulations and statutes themselves. And as I hope I've explained by now, that just doesn't put us on notice that we're supposed to stack discounts. I think that's the wrong reading of all of them. But also the idea that they had this audit. And as the district court found in this case, under Iqbal and Twombly, when there's an obvious, innocent explanation for that conduct, it's not enough to take something from beyond the realm of the conceivable to the realm of the plausible. And there are, I think, at least two reasons why that's just not a conceivable or just not a plausible interpretation. First is, as Judge Keenan already noted, the fact that if we were so worried this conduct was illegal, why were we only doing the audit part of the time? It's like we're not going to impress our regulator if they said, oh, well, you stopped doing double discounts for some of your business lines when we let other stuff go. And so the far more plausible explanation is we were doing it for business reasons, as Judge Keenan suggested. In addition, you have to look at the timing of that. That was in 2008. That was just after we got done with the 2007 rulemaking, where we told our regulator, this is our interpretation. And you're not going to hide anything from the regulator when you say this is our interpretation. So the far more plausible interpretation is that we understood this, we were doing this, the audits for business purposes.
All right, Mr. Elwood, your time is up. Thank you.
Thank you.
Thank you. A few points of clarification. Judge Berner, you hit the nail on the head when you asked my adversary, isn't that actual price realized? And he said, oh, no, it's net revenue. It's not. It's actual price realized. That's the exact issue in the case. That's exactly what they didn't report.
But isn't it actual price realized by whom?
By Forrest on the pill. That's the critical difference. My counsel on the other side keeps saying it's on a sale, it's on a manufacturer. That's not what the rule says. Look at the pill and the actual price realized on the pill unit. You asked the perfect right question, it was dodged, and that's the problem with their position. The second thing is, we have a fundamental dispute about this 2016, Judge Keenan, so I pulled the language. You asked the right question as well. Wasn't it clear in 2016? Here's what CMS said. A manufacturer is responsible for including all price concessions that adjust the price realized by the manufacturer for the drug in its determination of best price. If a manufacturer offers multiple price concessions to two entities for the same drug transaction, such as rebates to a PBM, where the rebates are designed to adjust price at the retailer provider level and discounts to a retail community pharmacy's final drug price, all discounts related to that transaction, which adjusts the price available from the manufacturer, should be considered in the manufacturer's final price of the drug when determining the best price to be reported for the drug. And we believe this policy is consistent with current Section 447.505E3. That's on page 31 of our complaint. It's 81 FR 5170. It's completely the opposite of what my counsel said was the case. There is no question of what they said in 2016.
But I think his argument is that those discounts flow to one entity, right?
Right. He's trying to say that when you adjust the price realized, that I'm looking at net revenue. I'm looking at the actual price realized for a particular unit. That's exactly what CMS advised. And the frustration with where we are today is that, as you said, Judge Berner, we don't know what they did. Forrest comes up, and I wrote this down. We read the 2007, and this was great. We have business reasons for what we're doing. We have no idea because there's no record. And what they're asking you to do is accept as true what they write in a brief and what they say at this podium that is inconsistent with what we allege in the complaint. Because in our complaint, we say they were not reasonable. They acted with scienter. They acted with deliberate disregard to what was happening in 2007. What they read and what they did is exactly what the point of discovery is, which we don't have.
Does the 9B standard apply to the pleading, is that the pleading requirement for scienter?
I'm sorry, I didn't hear you, Your Honor.
The heightened pleading standard for fraud, Rule 9B, does that apply?
No,
In the
all we have to
context
do
of
is
scienter?
all we have to allege is plausibility under Rothschild in the Fourth Circuit. And we did that. You have to accept our allegations as true, and our allegations are contrary to what they keep telling us in briefs and at the podium. If what we allege is true and inferences are in our favor, we can't accept, oh, they did it right, or they did it for business purposes. We need to know what happened. My counsel on the other side says, we asked CMS for guidance. The timing of that is critical because that was before rulemaking. CMS responds in 2007, and there's nothing in the record, not even in their briefs and not in presentation, of what happened afterwards. So respectfully, the district court opinion is wrong because it dealt with It didn't deal with the statute, and it dealt with scienter improperly. This court should either remand back to get it right, or it should interpret the statute to require stacking, find that our claims are plausible, and then send it back.
Thank
Under
you.
either situation, the district
Thank
court
you.
must be reversed. Thank
All
you.
right, thank you. All right, we will step down and greet counsel, and that is our final case for the day. Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.